a major shift in the fight for justice could be on the horizon. For years, the real possibility test has been seen as a true barrier preventing obvious wrongful convictions from reaching the Court of Appeal, and the controversial requirement to prove innocence beyond reasonable doubt for compensation claims, that too could soon be history. A new consultation paper published by the Law Commission suggests that these long-standing legal barriers may finally be removed. We are pleased to see, in particular, that we have been vindicated by the Law Commission as it concluded that the domestic law on compensation for miscarriages of justice does not meet the spirit of the obligation that the UK has accepted under the International Covenant on Civil and Political Rights, as we concluded in this video. But what does this all mean for those fighting to clear their names? And is justice finally catching up with fairness? Let's break it down. Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's video is part 1 of a 2 series in which we will examine the Law Commission project on criminal appeals. We will look at the context, the current status, and future expectations. Some preliminary points. First, as you probably have noticed, I have a terrible tonsillitis. My voice is not at its best. Secondly, before we start, don't forget to subscribe to help us continue our discussion into reforming the criminal justice system to ensure that it serves people, not just rules. And finally, we will only touch on the context of the consultation paper very briefly here. For in-depth analysis and to find out more on the background context, check out these videos, which we have now included in a new playlist titled Criminal Appeals Reform. So let's start with the context. When introducing the Criminal Appeal Act 1995 at its second reading in the House of Commons, the then Home Secretary Michael Howard said, "We share a common interest in ensuring that our system is the best we can provide, that it contains all the necessary safeguards to minimize the possibility of a wrongful conviction. The most effective appeals procedures that we can devise and the best machinery for investigating possible miscarriages of justice." By the best machinery to investigate possible miscarriages of justice, he, of course, referred to the Criminal Cases Review Commission, the new body proposed in that bill to investigate miscarriages of justice. However, 20 years on, in 2015, a Justice Select Committee review into the CCRC highlighted significant concerns about the CCRC's powers, approach, and resources. This then led to the establishment of an all-party parliamentary group on miscarriages of justice in 2019. And in turn, this led to the creation of the Westminster Commission, tasked with reviewing the Commission's work. The Westminster Commission gathered evidence from a wide range of sources, including legal practitioners, academics, and individuals with direct experience of the criminal justice system, whether as lawyers, witnesses, or defendants. And among those were also those who believed they had been denied justice. The Commission's findings, which can be found in a report called In the Interest of Justice, painted a troubling picture of the CCRC. It highlighted chronic underfunding, which significantly hampered the CCRC's ability to function effectively. Moreover, it criticized the real possibility test, which allows the CCRC to refer a case to the Court of Appeal only if it believes that the appeal has a real possibility to succeed. The Commission argued that the predictive nature of the test has made the CCRC overly deferential to the Court of Appeal. Instead of acting as an independent body dedicated to identifying miscarriages of justice, the CCRC was seen as operating under constraints that limited its decision-making freedom. The report also raised concerns about a target-driven culture within the CCRC, where the pressure to resolve cases often came at an expense of thorough and detailed investigations. This emphasis on expediency, the Commission warned, risked compromising the integrity of the reviews and ultimately justice itself. Additionally, serious issues were noted regarding the non-disclosure or even destruction of exculpatory evidence, further undermining confidence in the system. Communication was another key area of concern, both in terms of keeping applicants informed about the progress of their cases and explaining the CCRC's approach. A lack of transparency and engagement, the Commission concluded, had eroded trust in the CCRC's ability to fairly and effectively review potential miscarriages of justice. The report additionally recommended that the Law Commission should review the test applied by the Court of Appeal under the Criminal Appeal Act 1968 to allow it to quash a conviction when it is a serious doubt about the verdict, even without fresh evidence or new legal argument. As a result of these concerns, in July 2022, the Law Commission was tasked with reviewing criminal appeals, aiming to present a provisional proposal by the end of 2024 and a full report with recommendations in 2025. However, that provisional report was only published on the 27th of February 2025, as we announced in our introduction, as part of a new consultation paper with feedback open until the 30th of May 2025. And we are now told that the final report, along with recommendations, is expected in 2026. The Law Commission has pointed to an expansion of the review's scope in 2024 to include the issue of compensation. While compensation was mentioned in the original consultation, specifically at question 10, it now appears to have become a more central focus. So, should we be disappointed by this further delay? Of course it is disappointing. That said, however, we will not be overly critical of the timing, considering both the complexity of the task and the extraordinary developments that unfolded in the meantime, many of which are referenced in the consultation paper. These include the overturning of Andrew Markinson's conviction, the CCRC review of its handling of the case by Chris Henley KC, the enactment of the Post Office Horizon System Offences Act 2024, and the recent review of the criminal courts led by Sir Brian Levison, launched by Shabana Mahmood in December 2024. Incidentally, the consultation paper says December 2023. This is clearly an error. We also observe that despite the recent controversy surrounding the Lucy Letby case, this has not been explicitly mentioned in the recent developments by the Law Commission. However, we suspect that certain additions have been influenced by the events related to this case. For instance, the provision for a court-appointed or independent expert on appeal. The point we make is that each of these developments has played a significant role in expanding and reshaping the scope of the review. Ultimately, while we share the frustration over delays, we believe it is more important for the Law Commission to thoroughly consider these highly relevant developments rather than rush to meet an arbitrary deadline at the cost of a comprehensive and meaningful review. Now that we have covered the background and where things stand, let's dive into the consultation paper itself. And it's not a light read, let me tell you. It comes in at a hefty 725 pages. Due to time constraints, we won't be able to cover every aspect of the consultation paper today. Instead, we have selected the key areas that have shaped most of our videos so far. I have also included a link to the Law Commission project page so that you can explore it at your own pace. Let us know which topics you would like us to delve into or clarify in future videos. For example, we will be addressing in a future video whether the requirement for the Court of Appeal to certify that a case raises a point of law of general public importance should be removed. A key issue relevant on the LIBOR cases, which we have covered in some of our videos. We plan to explore this in March when Tom Hayes' case is set to be heard by the Supreme Court. Similarly, we will examine the substantial injustice test in a dedicated video. This is particularly relevant to joint enterprise cases, which we have discussed in several of our videos. Rather than incorporating it into this broad discussion, we believe it deserves focused analysis to fully unpack its implications. This video will explore the Law Commission's provisional conclusions on key issues, including the general principles governing criminal appeals and potential changes to the test and time limits for the Court of Appeal in convictions on indictment. In the second part next week, we will turn our focus to the proposed reforms concerning the Criminal Cases Review Commission and the issue of compensation for miscarriages of justice. Let's begin with the general principles that should govern criminal appeals. History makes it clear that the primary function of the right of appeal is to correct miscarriages of justice, a fundamental concept that lies at the heart of our channel's mission. One of the key terms of reference in the Law Commission's project is to assess whether the test applied by the Court of Appeal may obstruct the correction of miscarriages of justice. It is therefore unsurprising that the Law Commission's first step is to establish a clear definition of miscarriage of justice as a foundation for its consultation paper. Rather than narrowly tying it to innocence or guilt, the Law Commission takes a broader approach, defining a miscarriage of justice as a failure of the court or judicial system to attain the ends of justice. We fully support this perspective as it acknowledges the inherent difficulty in proving innocence in many cases. We have often referenced Baroness Kennedy's insightful remark that one of the core principles of our legal system recognizes the inherent difficulty of proving innocence. The presumption of innocence and the burden on the state to prove a case are clear extensions of this principle. So we fully support the Law Commission's broad definition of miscarriage of justice and agree that nonetheless the clearest example of miscarriage of justice remains, of course, the wrongful conviction of those who are factually innocent. However, proving factual innocence is often an extraordinarily difficult, if not impossible, task, particularly when evidence has been lost, witnesses are no longer available, or forensic advancements are not accessible at the time. In many cases, the closest we can get to demonstrating innocence is proving that the legal system has failed to deliver justice, whether through flawed procedures or unreliable evidence. By broadening the definition of a miscarriage of justice, the Law Commission acknowledges that a system committed to justice must correct all wrongful convictions, not just those where absolute innocence can be established beyond doubt. Having established that, the Law Commission then focuses on the principles that should govern criminal appeals. These are not necessarily those that shape the broader criminal justice system. While there are overlapping concepts, such as the right to fair representation, some fundamental distinctions must be recognized. For example, while the presumption of innocence is a fundamental pillar of the criminal justice process, it no longer applies once a guilty verdict has been delivered. Similarly, the principle of finality, which ensures that criminal cases are not endlessly re-litigated, providing certainty to victims, defendants, and society, can come into direct conflict with the need to reopen cases when evidence suggests a wrongful conviction. Another key tension arises from the role of jury supremacy, since in most of the serious cases, jury hold the ultimate responsibility for determining guilt. There is often resistance to the idea of the Court of Appeal overturning their decisions. This creates a complex dynamic where the appeal system must balance respect for jury verdicts with the duty to correct miscarriages of justice. Navigating these competing interests remains one of the greatest challenges in ensuring a fair and effective appeals process. The Law Commission has reached a conclusion on the principles that should inform criminal appeals and is seeking views from consultees. This is a question 3 of the long consultation paper, or question 1 in the summary paper. In considering whether reform to the law relating to criminal appeals is necessary, we provisionally propose that the relevant principles are: 1. The acquittal of the innocent, the conviction of the guilty, fairness, recognizing the role of the jury in trials on indictment, upholding the integrity of the criminal justice system, ensuring access to justice, incorporating the no greater penalty principle and consideration of the needs of particular groups, and 7. Finality. We provisionally propose as an overriding principle that the convictions of those who are innocent or did not receive a fair trial should not stand. Do consultees agree? Whilst we agree with the identified principles, we have reservation as to the overriding principle proposed by the Law Commission. We are of the view that the overriding principle should be broader and should be the correction of injustice. relying solely on the principles of innocence, which, as we previously noted, can be exceptionally difficult to prove, or fair trial, which does not always guarantee a just outcome, makes the framework both restrictive and challenging to apply in practice. An unjust verdict can arise even from a procedurally fair trial, so the focus must be on ensuring that justice prevails. These aligns with the Law Commission's definition of miscarriage of justice, which we referenced earlier, as a failure of court or judicial system to attain the ends of justice. And what do you think? Let me know in the comments below. It's important to note that while the Law Commission's paper has a broader scope covering all appeals, including those from convictions and sentences in the magistrate's court, our focus will be solely on appeals to the Court of Appeal Criminal Division arising from convictions in the Crown Court. With that in mind, let's examine the right of appeal and the current powers and limitations of the Court of Appeal. As we know, in the UK, there is no automatic right of appeal against a conviction. Instead, an appeal can only proceed with the permission known as leave of the Court of Appeal and, in exceptional circumstances, with a certificate that the case is fit for appeal granted by the trial or sentencing judge. Even if leave is granted, the appeal will only succeed if it can be demonstrated that the conviction is unsafe, meaning that there was a significant legal error, procedural unfairness, or new evidence that undermines the reliability of the verdict. This is how things stand today. Leave from the Court of Appeal must be sought within 28 days from the conviction. If in the interest of justice, then this limit can be extended. Applications for leave are decided in the first place by a single judge in the Court of Appeal. If they believe that the appeal is arguable, i.e., it has reasonable prospect of success. If leave is granted, then the appeal is decided by the full court. If the application for leave is refused by the single judge, then an applicant can renew the application for leave before the full court. If the full court denies application for leave, this means that the applicant has exhausted their right to appeal, and the only remedy available to them is an application to the CCRC to refer the case back to the Court of Appeal. Some of our community members have referred to the fact that there should be an automatic right to appeal. Well, this is not something that the Law Commission has included in its proposal. The consultation paper agrees with a leave to appeal, as it serves as a filter to weed out appeals that would have no reasonable prospect of success if leave were to be granted, and to enable the court to concentrate its judicial resources on cases that have something in them. As per the 28 days time limit, a number of consultees raised concerns with the 28-day limit. A consultee, Mark Alexander, a prisoner who claims to have been wrongly convicted of the murder of his father, and whose case we refer to in this video, reported that the 28-day time limit is clearly problematic, since it is quite impossible to find fresh evidence within that time, particularly in light of the fact that legal aid funding expires at the point of conviction. The Law Commission also added that legally aided defendants are entitled to advice from their their representatives as to whether they have grounds for appeal. Not only does this process itself take time, but if their representatives' advice is negative, defendants may well have very little time to formulate their own grounds or to seek alternative advice. So, question 16 of the long consultation paper, or question 3 of the summary paper, states, we provisionally propose that the time limit for bringing an appeal against conviction or sentence to the Court of Appeal Criminal Division should be increased to 56 days from the date of sentence. Do consultees agree? We believe this change is welcome and agree with the Law Commission that the current time limits are potentially capable of causing injustice. Now, let's turn to another issue we have focused upon on many occasions, the issue of fresh evidence dealt with in Section 23 of the Criminal Appeal Act 1968. We explored this topic in some details in this video dedicated to the recent fresh expert evidence presented by an international panel in the case of Lucy Letby. We emphasized that the law is, in our view, clear in that there are 4 considerations for admitting fresh evidence, which are referred in Section 23, subsection 2, and that this must be taken as such, literally as considerations rather than strict criteria that the applicant must meet. The legal framework itself is, in our opinion, clear. The Court of Appeal has broad discretion to admit fresh evidence, guided primarily by the interest of justice. However, in our conclusion in that video, we acknowledged that in practice the outcome can be unpredictable. While the law provides flexibility, the courts have applied this discretion far more narrowly than the statute suggests. Lots of consultees have provided their views, and in our opinion, the closest to our views was expressed by JENGPA, which submitted that while the discretion to admit fresh evidence is supposedly a wide one focusing on the interest of justice, in reality the threshold for admission is exceptionally high. They argue that the default position appears to be that the fresh evidence will not be admitted unless the defendant can prove that neither they nor their legal representatives were at fault for failing to present it at trial. This practical limitation significantly restricts access to justice and raises concerns about whether genuine miscarriages of justice are being properly addressed. The Law Commission did consider whether it would be better to impose a duty to admit fresh evidence in certain circumstances, essentially returning to the position that existed before 1995. However, the Law Commission noted that the same concerns were expressed when the law did impose such a duty. It seems that really this must be one of those issues that should be embraced as a change in attitude and approach on the part of the Court of Appeal rather than as a change in the law. The Law Commission conclusions are in question 17 of the consultation paper, or question 6 of the summary paper, which reads, we provisionally propose that the test for admitting fresh evidence in Section 23 of the Criminal Appeal Act 1968 should remain in the interest of justice, provided that the consideration in subsection 2 are treated as such rather than as criteria which must be met before fresh evidence can be admitted. Do consultees agree? While we understand the reasoning behind this approach, we believe it grants excessively broad discretion to the court and depends too heavily on its willingness to adopt a more flexible stance. As a result, it fails to adequately address the underlying issues surrounding the admission of fresh evidence already highlighted by many consultees. This could ultimately continue to be an issue if not addressed at a legislative level. A novel point included in this consultation paper is whether the Court of Appeal should have the power to appoint its own experts in order to assist it in determining appeals. Though this is not expressly mentioned, we wonder whether this is one of the points which have come from the reflection of the Lucy Letby's case. In our news session in the name of justice, we reported how Dr. Michael Hall, who was one of Lucy Letby's experts but was not called to give evidence, commenting on the misinterpretation of Professor Shu Lee's paper, an error that was overlooked by the Court of Appeal, suggested that the Court of Appeal have likely recognized this issue had it sought an independent opinion from a suitably qualified expert. We saw merit in his point. This is relevant to question 18 of the consultation paper, which states we invite consultees' view on whether the Court of Appeal Criminal Division should have a power to appoint its own experts in order to assist it in determining appeals, what the nature of such power might be, and what constraints, if any, there should be on the exercise of such power. We support the idea that the Court of Appeal should have authority to appoint its own experts. However, we have not yet had the opportunity to fully consider the scope and limitations that should be placed on this power. Perhaps this is a point that we can develop further in the comments below. Moving on to the test for appeal against conviction. As we know, the sole ground for an appeal against conviction is whether the conviction is unsafe. The Law Commission explains unsafe as an umbrella term, apt to cover both factual innocence and the possibility of factual innocence, which can also, in some circumstances, cover serious procedural irregularity or other unfairness and abuse of process. The proposal is that the single ground that a conviction is unsafe remains the test for quashing a conviction, but that the circumstances in which a conviction will be unsafe should be set out non-exhaustively in legislation to include whether the court considers that the appellant's trial as a whole was unfair, or where the court considers that the conviction of the appellant involved abuse of process amounting to an affront to justice. This is set in question 34 of the consultation paper or section 8 of the summary paper. How the safety test is applied depends on the circumstances. In cases where fresh evidence is admitted, the Law Commission has acknowledged the views by many consultees, and our view as well, that the Court of Appeal often fails to take a holistic and cumulative view of each appeal point, especially in cases of circumstantial evidence, which is the point we made when we analysed the recent appeal in Oliver Campbell. The Law Commission has determined that the Ransman Commission approach on this point, namely that where there is fresh evidence that could have led the jury to acquit, that should be, if possible, a retrial, is sound. And consequently, its proposal is at question 35, that where in an appeal against conviction, the Court of Appeal Criminal Division admits fresh evidence that could have led the jury to acquit, then the court should order a retrial unless a retrial is impossible or impractical. We welcome this approach. The safety test also applies in cases where there is what has become to be known as lurking doubt. The concept of lurking doubt in the Court of Appeal refers to situations where, despite there being no specific legal error, the judges have a residual unease about the safety of the conviction. This allows the court to overturn a conviction even when the formal legal tests for appeal are not necessarily met, but where the judges feel something about the case suggests a potential miscarriage of justice. The principle originates from a case, Regina v. Cooper, where the Court of Appeal ruled that even if the conviction was supported by evidence, it could still be set aside if, upon reviewing the case, the judges had the inherent sense that the conviction might be unsafe. However, the Court of Appeal has been reluctant to rely on the lurking doubt principle, often preferring more concrete legal grounds, such as new evidence, procedural errors, or misdirections in law. This reluctance was expressed in the case of Regina v. Pope, where the court confirmed that it is not open to the court to set aside the verdict on the basis of some collective subjective judicial hunch that the conviction is or may be unsafe. We, along with others advocating against miscarriages of justice, have argued that this reluctance has made it more difficult to overturn wrongful convictions based on a broader assessment of fairness and justice, an essential safeguard in cases where fresh evidence or procedural irregularities cannot be adduced. The Law Commission question 36, we provisionally propose that the Court of Appeal Criminal Division should continue to be able to find the conviction unsafe if it thinks that the evidence taken as a whole was insufficient for a reasonable jury to be sure of a defendant's guilt. Do consultees agree? Of course, we agree that this ground should remain in place. However, we are not convinced that the Law Commission's decision to take no action will effectively address the issue. We believe this ground requires legislative clarification to ensure its proper application. Otherwise, it risks remaining unused, just as it has been for the past 15 years. And what do you think? Let me know in the comments below. This wraps up the first part of our preliminary review of the consultation paper. Next week, we will focus on the chapters addressing the CCRC, miscarriage of justice compensation, and other key areas related to systemic miscarriages of justice and prevention. As always, I hope this will spark some meaningful debate in the comments below. Also, subscribe if you haven't already to help us reach a wider audience so that we can work towards shaping a criminal justice system that serves people, not rules. Join us again as we sit and rise in this unique trial.